Beneath the blinding studio lights of CNN, the atmosphere felt unusually tense. This wasn't just another political panel. This was supposed to be a public takedown. Seated calmly at the debate table was Jasmine Crockett, dressed in a deep maroon suit that reflected quiet confidence rather than flash. Her posture was relaxed, her hands neatly folded, her expression unreadable. To casual viewers, she looked composed. To those who knew her courtroom history, she looked ready. Moments earlier, backstage doors had swung open and Alan Dersowitz had stepped into view. At 85 years old, Dersowitz carried decades of reputation on his shoulders. A Harvard law professor emeritus, a man who had argued before the Supreme Court dozens of times, a legal celebrity whose name alone commanded authority. In his hand was a thick stack of papers, court rulings, highlighted passages, annotated notes, visual proof of dominance. "I brought evidence," he told the producer, his voice firm and confident, "that will expose her lack of constitutional understanding." The message was clear. This was meant to be a lesson, not a debate. Phones were already rising in the studio audience. Everyone sensed it. This was going to be confrontational television. To the network, it looked like a safe bet. A legendary legal scholar versus a congresswoman barely 2 years into her term. Experience versus youth. Prestige versus politics. What no one in that room realized was that this matchup had been miscalculated from the start. Crockett wasn't new to confrontation. Before Congress, she had spent years as a public defender and civil rights attorney, fighting uphill battles in hostile courtrooms. She had faced judges who doubted her, prosecutors who underestimated her, and systems stacked against the people she represented. She knew the look of arrogance. She also knew how to dismantle it. As cameras began rolling, the moderator introduced a segment, a discussion on the Voting Rights Protection Act, a bill already dividing the nation. Dersowitz sat upright, silver hair perfectly combed, navy suit immaculate. His expression was resolute, almost dismissive. Crockett met his gaze without blinking. The stare-down lasted only seconds, but it told a real story. This was not going to be an easy win. The host opened with formal introductions, highlighting Dersowitz's decades in academia, his Supreme Court appearances, his high-profile clients. Then she turned to Crockett, noting her background as a civil rights lawyer and her first term in Congress. Dersowitz smiled thinly. When he spoke, the condescension arrived immediately. "I've been teaching constitutional law since before Congresswoman Crockett was born," he said smoothly. "I believe the American public deserves insight from someone who actually understands the legal complexities involved here." The implication landed hard. Across the table, Crockett didn't react. No eye roll, no defensive posture, just a slow inhale and a calm nod. When it was her turn, she spoke evenly. "I'm not here to lecture Americans from an ivory tower," she said. "I'm here to talk about how this legislation affects real voters, people I've represented in court and now represent in Congress." The tension spiked. The moderator posed a central question. Was the bill constitutional, or was it federal overreach? Dersowitz didn't wait for Crockett to answer. "This bill is unconstitutional," he declared. "It strips states of authority clearly reserved to them. I'm frankly surprised anyone with a law degree would support it." That's when Crockett smiled, not in amusement, but in recognition. She had seen this tactic countless times. Dominate early, undermine credibility, force the opponent into defense mode. What Dersowitz didn't know was that Crockett had spent days preparing, not just reviewing the bill, but studying him, his writings, his testimony, his past contradictions. The debate had barely begun, and already the balance of power was shifting. Crockett leaned slightly forward, her tone measured but firm. "Let's start with the Constitution itself," she said. Article 1, Section 4 gives Congress authority over the times, places, and manner of federal elections. The 14th and 15th Amendments reinforce that power. Dersowitz shook his head. "You're oversimplifying," he replied. "The Supreme Court has consistently affirmed state control, particularly in Shelby County versus Holder." "I'm familiar with Shelby County," Crockett responded calmly. "I've litigated cases directly impacted by it. That ruling did not eliminate Congress's authority. It required updated evidence. This bill provides exactly that. The moderator attempted to move the discussion to early voting provisions. Dersowitz seized the moment. These federal mandates will create chaos, he argued. Uniform standards ignore state realities. This is ideology over practicality. Crockett waited for him to finish. Interesting, she said, because in your 1982 book Rights of the People, you argued that federal standards were necessary when states showed patterns of discrimination. You specifically endorsed national early voting protections. The camera caught Dersowitz blinking. Academic thought evolves, he said quickly. Does constitutional principle evolve, Crockett asked, or political convenience? The audience stirred. From there, the discussion turned to voter ID laws. Dersowitz dismissed claims of disenfranchisement as exaggeration. Crockett's voice sharpened, not louder, just firmer. I've represented elderly citizens without birth certificates, workers who can't take unpaid days off to visit ID offices. These are not hypotheticals. Dersowitz waved it off. Anecdotes don't override constitutional authority. Evidence does, Crockett replied, and your own writing acknowledges that. She quoted his 2005 Harvard Law Review article criticizing selective constitutional readings used to justify restrictive voting laws. This is out of context, he snapped. Would you like me to read the full paragraph? She asked. The moderator cut to commercial. Off camera, Dersowitz whispered urgently to his aide, flipping through papers. Crockett sipped water, calm as ever. When the broadcast resumed, Dersowitz tried a new angle, credentials. I've argued over 50 Supreme Court cases, he said. With respect, your brief tenure hardly qualifies you to lecture me. Crockett didn't flinch. This isn't Harvard law, she said, and I'm not your student. The studio went quiet. Crockett shifted gears. In December 2020, she said, you argued that state legislatures weren't bound by their own constitutions when appointing electors, a theory that would have nullified millions of votes. She held up a printed statement. How does that square with your current concern for federalism? Dersowitz hesitated. That was a narrow argument, he said. Both deal with the same principle, Crockett replied. Federalism versus voter protection. Yet your interpretation changes depending on who benefits. The audience murmured. She continued, citing Shelby County again. This time quoting Chief Justice Roberts' acknowledgement of Congress's enforcement power. You keep invoking that case, she said, but it doesn't say what you suggest. Dersowitz attempted to interrupt. Crockett raised her hand. I listen respectfully to you, she said. He stopped. She described real-world impacts. Polling places closed, voter rolls purged, communities silenced. This isn't abstract theory, she said. This is lived reality. The moderator asked Dersowitz to respond. He doubled down, pointing to Section 306 as evidence of federal overreach. Crockett smiled slightly. That section, she said, is modeled on your 1991 House Judiciary testimony, where you endorsed similar measures. She slid the transcript across the table. The room fell silent as Dersowitz read. His confidence visibly cracked. Trying to recover, Dersowitz made his biggest mistake. Section 502, he argued, could weaken minority voting power. Crockett paused. There is no Section 502 in this bill, she said calmly. It has 428 sections. Silence. Dersowitz shuffled papers, face flushing. I meant Section 402, he corrected. That section concerns ballot drop boxes, Crockett replied. You're thinking of a different bill entirely. The moment said everything. Despite decades of prestige, Dersowitz hadn't fully read the legislation. Crockett had helped draft it. The moderator asked if Dersowitz wished to revise his position. I'll need to review the text more closely, he admitted. Crockett nodded graciously. I'd be happy to share a full analysis. The segment ended. Within minutes, clips flooded social media. Hashtag Crockett Clapback trended nationwide. Legal commentators across ideological lines acknowledged the performance. She brought specifics. One analyst said, he brought reputation. The fallout was immediate. Interview requests poured into Crockett's office. Her following tripled overnight. House leadership invited her to lead the next day's press conference. Even Dersowitz issued a statement acknowledging her command of the issue. Weeks later, he requested a private meeting. "I underestimated you," he admitted. "Your reasoning was sound." They later co-authored an op-ed calling for a substantive debate over status. The bill gained momentum. Law schools studied the exchange. Voting rights enrollment surged. Young lawyers, especially women of color, flooded Crockett with messages of gratitude. "You showed us we don't have to shrink," one student wrote. 6 weeks later, the bill passed the House. What began as a planned humiliation became a turning point, a reminder that in modern democracy, authority no longer comes from titles alone, but from preparation, courage, and truth.